Hello, welcome to our program. Today we'll talk about contract law. It's difficult to imagine going very long before making some kind of agreement enforceable by law. Whenever we buy goods and services, we enter into a contractual relationship. So, you have to raise this kind of question to yourself. What is necessary for a valid contract to be formed? Contract law deals with promises which create legal rights. In most legal systems, a contract is formed when one party makes an offer that is accepted by the other party. Some legal systems require more, that the parties give each other or promise to give each other something of value. In common law systems, this promise is known as consideration. In those systems, a one-sided promise to do something does not lead to the formation of an enforceable contract, as it lacks consideration. For instance, a promise to make a gift. So, another question to you. What is necessary for a valid contract to be formed? You have to reply like this. An offer must be made and it must be accepted. As I mentioned before, in some legal systems, the parties must give or promise to give each other something of value. When the contract is negotiated, the offer and acceptance must match each other in order for the contract to be binding. This means that one party must accept exactly what the other party has offered. If the offer and acceptance do not match each other, then the law says that the second party has made a counter-offer, that is a new offer to the first party, which then may be accepted or rejected. For there to be a valid contract, the parties must agree on the essential terms. These include the price and the subject matter of the contract. Contracts may be made in writing or by spoken words. If the parties make a contract by spoken words, it's called an oral contract. In some jurisdictions, certain special types of contracts must be in writing or they are not valid. For instance, I can give an example as in the sale of a house. The contract gives both parties rights and obligations. Rights are something positive which a party wants to get from a contract. For instance, the right to payment of money. Obligations are something which a party has to do or give up to get those rights, the obligations to do work, for instance. When a party doesn't do what it is required to do under a contract, that party is said to have breached the contract. The other party in this issue may file a lawsuit against the breaching party for breach of contract. The breaching party, also we called the injured party, may try to get a court to award damages for the breach. Damages refers to money which the court orders the breaching party to pay to non-breaching party in compensation. Other remedies include specific performance, where a court orders the breaching party to perform the contract, to do what it promised to do, A party may want to transfer its rights under a contract to another party. This is called an assignment. When a party assigns, so-called gives, its rights under the contract to another party, the assignment party is called the assignor, and the party who gets the rights is called the assignee. So, what is the question here? The question, which two remedies following a breach of contract are mentioned? You have to reply that the two remedies mentioned are damages and specific performance. So, decide whether these statements are true or false. Okay, it's your turn now. In all legal systems, parties must give something of value in order for a contract to be formed. Okay, I repeat again. In all legal systems, parties must give something of value in order for a contract to be formed. Is it false or true? What you're saying? It's false. Why? Because it's not in all legal systems, but in most legal systems, parties must give something of value in order for a contract to be formed. Okay, another question for you. An offer must be met with a counter offer before a contract is agreed. So, what do you think? Is it true or false? Okay, it's false again. Why? An offer must be accepted before a contract is agreed, right? So, another question for you. Oral contracts are not always valid. Is it true or false? Yes, it's true. Oral contracts are not always valid, as I mentioned before in the excerpt. Another question. If in breach, the court will always force the party to perform the contract. Is it true or false? False. A court may force the party to perform the contract, but not always. May force, right? Assignment. Okay, another one. Assignment occurs when one party gives its contractual rights to another party. I'll repeat again. Assignment occurs when one party gives its contractual rights to another party. Is it true or false? Yes, it's true. Well done. Okay, this time we'll complete the sentences using the words below. You're going to use the word breach, counteroffer, damage, formation, obligations, oral contract, or terms. So, okay. First question. Usually, contract occurs when an offer is accepted. What are you going to put in it? Usually, contract formation occurs when an offer is accepted. We are talking about the contract formation. Another one, a new offer made by one party to another party is called a counteroffer. Another offer, if there is another offer exists, we call it counteroffer. Another one, the price and the subject matter of a contract are the essential terms of a contract. Yes, there are essential terms of a contract. What we are talking about? About the price and the subject matter of a contract. Another one, a contract which is not in written form but has been expressed in spoken words is called an oral contract. Of course, we are talking about the spoken words, so it's called an oral contract. What else? Another one. Under a contract, a party has obligations, right? Yes, has obligations. Certain things it has to do. Another question for you about the breach, okay? When a party doesn't do what it has promised to do under a contract, it can be sued for breach of contract. Well done. Another one is coming. A court can award damages to the non-breaching party. What is the other name of damages? Compensation. So what do you think about damages, the word damages? Damages is not plural. You have to bear in mind that it's singular. So it is legal term. Damages equate to compensation, it means the same. Okay, let's move on. Match the verbs below with the nouns they go with in the text now. What we have? An offer. You already mentioned about the offer. A contract. Enforce a contract. Okay. A contract, damages, a lawsuit. An offer. If I mention about the offer, what kind of sentences you can now set up? Accept an offer, you can say. Yes. Make an offer. Reject an offer. And also you can negotiate an offer. What about the contract? So you see that the other party one of the parties may breach the contract. Breach a contract, so form a contract. We talk about the formation of the contract already. Negotiation, negotiate a contract. You can negotiate a contract and perform a contract. What about the enforce? Enforce a contract is possible as well. So, what about the damages? Damages, you can award or court award damages, right? And the injured party or breaching party may accept damages. What about the lawsuit? A lawyer file or the party file a lawsuit is possible. Okay, so you can make this kind of sentences as legal terms. You have to bear in mind and pay attention what you use it. So look at each of the verbs except a word: breach, enforce, file, form, make, negotiate, perform, reject, and discuss the subjects: a party, the parties, the court, a lawyer can carry out the action in question. So, okay, we'll make a sentence about this, all the verbs. We're going to use all the verbs and the verb. So, the first one, we can just make a question now, okay, sentence. A party accepts an offer, and a lawyer can accept an offer too. See? But a court cannot accept an offer. So, you can only use for either for the party or for a lawyer to accept an offer. A party makes an offer. A party accepts an offer. A party rejects an offer. A party, what else? Breaches a contract. Also performs a contract. What about the parties? The parties negotiate an offer. The parties negotiate a contract also, is possible, right? The parties form a contract. So, what about the court? The court enforces a contract, or the court awards damages. A lawyer, when we mention about the lawyer, a lawyer files a lawsuit, as I mentioned before. A lawyer negotiates an offer, and also a lawyer may negotiate a contract. What about the remedies? Remedies for breach of contract. If a contract is broken, the injured party, you can also call it breaching party. The injured party, non-breaching party, the injured party here, might be accepted to demand any of the following. So, if the injured party, if the contract is broken, the injured party has some legal rights to demand as follows. What else? To have what they gave returned to them, which is called restitution. Also, he may demand compensation for their loss. We call it damages. Compensation is equal to damages. Sorry. And what else? So it became very little. Let's make it a bit bigger to see it. Daha büyük yapalım. Evet. Okay. We are just talking about the remedies now. We mentioned about the breaching party. Okay. So, what else? As a third one, the other party to be forced to perform the contract. We call it specific performance. In the common law tradition, damages is the usual remedy that a court awards words for a broken contract. Restitution and specific performance are available only in certain circumstances. So you have to bear in mind that what we have here, we are talking about the common law tradition. Damages is the usual remedy, okay, that occurs for a broken contract. But if we talk about the restitution or specific performance are available only in certain circumstances, we say it. So, okay, what kind of question we can raise here? What does the word remedy in the text mean that I mentioned to you? The term remedy refers to the means to achieve justice in any matter in which legal rights are involved. So, what is the most common remedy for breach of contract in the legal systems of English-speaking countries? I mean, what does English-speaking countries mean? Commonwealth countries I'm talking about, in common law system. The common remedy is damages. So, we'll ask for clarification and giving some explanations. So, listen to the first part of a short conversation we have here between two law students who are discussing the law textbook excerpt. What is the first student confused about? Just pay attention. What is the first student confused about, okay? Student 1, we have student 1 and student 2. So, okay. Can you take a quick look at this? Sure. What is about? It's about remedies and damages and other things like that. Okay, what do you want to know? I basically understand everything, but there is one thing that sounds weird. Here it says that if a contract is broken, the injured party can demand compensation for its loss or damages. I don't understand that. How can damages be compensation for loss? That doesn't make sense to me. When you damage something, you harm or hurt it. I don't get it. This student is confused here about the meaning of the word damages, which refers to money paid in compensation for a loss. He confuses it with the word damage. That's why I already mentioned to you. Pay attention, I said to you. Damage is something else, it's a legal terminology. It's very equal to compensation, which refers to money paid in compensation. The other one is to hurt something, to harm something. Okay? So, this is the legal term. So, listen to the beginning of the lecture on contract law. What is the general subject of the lecture? Okay, I'm going to read something to you here. Good morning. I'll begin today's lecture on contract law with the subject of formation. More precisely, I will speak about the requirements for formation of contract. There are two main requirements: agreement and consideration. There is sometimes said to be a third element, the intention to create legal relations. However, in practice, this third element is not usually a problem because even if the intention to create legal relations is considered a separate element, it's understood to exist automatically in the vast majority of cases. So, what was the question? What is the general subject of the lecture here? The general subject of the lecture is contract formation. Okay, listen to the whole lecture now and answer following questions. Good morning. I'll begin today's lecture on contract law with the subject of information. More precisely, I will speak about the requirements for formation of contract. There are two main requirements. We call it agreement and consideration. There is sometimes said to be a third element, the intention to create legal relations. However, in practice, this third element is not usually a problem, what we said, because even if the intention to create legal relations is considered a separate element, it's understood to exist directly in the vast majority of cases. What does agreement mean in the context of the contract? agreement mean? Agreement refers to the transformation of negotiations into a settled deal. This is the point when negotiations are at an end. The negotiating process is not a part of the contract. You have to be careful here. However, the law needs to be able to determine when the process of negotiation has ended and the parties have reached an agreement in their commercial arrangement. Traditionally, if you want to answer the question, have the parties reached agreement, you apply the rules of offer and acceptance. When a proper offer has been made by one party and accepted by the other, then there is agreement at the moment of acceptance. Be careful, there is agreement at the moment of acceptance. We could even say there is agreement at the moment of communication of acceptance, you might say as well. So, this process raises a number of questions, of course. For example, was an offer made at all? Who makes an offer in certain types of transactions? For example, in auctions or tenders. Is a price list an offer? Is an advertisement an offer? Well, this kind of question you have to reply here. It's then also necessary to answer further questions about the act of acceptance. For example, does acceptance have to be communicated? Can you accept by silence? Can you accept by just getting on with the commercial task? Let's move on to the subject of consideration. Consideration involves the idea of exchange. It refers to the value, service, information, and so on, which is offered to another party in a contract in exchange for that party's agreeing to enter the contract. So, it refers to the value, I repeat again, the value, service, information, and so on, which is offered to another party in a contract in exchange for that party's agreeing to enter the contract. Put very simply, what we are talking about here is the price. Okay, we are talking about the price. A contract is not legally binding if each party doesn't offer at least some consideration to the other party. So you need to see in the contract the consideration. Either the value or service or information or the price, right? There are rules about what an exchange is and what parties can exchange in order for it to be good consideration. There is a relationship between the rules of offer and acceptance on the one hand and the rules of consideration on the other hand, right? So, which of these terms does the speaker mention here? Agreement or counteroffer? We are talking about consideration, acceptance, negotiation, remedy or offer. The speaker mentions the terms agreement, consideration, negotiation, offer and acceptance here. Complete this excerpt from a student's lecture notes by writing one word in each space, okay? So, we are talking about the introduction lecture on contract formation. 3 requirements for formation. One, we have agreement, consideration, and intention to create legal relations. Agreement, when negotiations become a settled deal, right? When an offer is made and accepted also, when an offer made and accepted, what we have? There is an agreement. Questions about offers, for example, who makes an offer in an auction? So we are talking about the price list. An offer is an advertisement, an offer, yes, price. We are talking about the price list, is an offer or is an advertisement an offer. Questions about acceptance. Does acceptance have to be communicated? Except by silence, consideration basically means the price. If there is no consideration, the contract is not legally binding. So that's why you have to be careful that you have to see the consideration in the contract, right? So, this is the end of this program. Thank you for watching and see you next time. Bye-bye.